Thank you very much, Professor Schiavo. I'm sure everyone here enjoyed your insightful presentation. And our third speaker is Marton Ribary, who studied philosophy with classic and Hebrew in Budapest and completed a master in philosophy in Second Temple Judaism and early Christianity. Before starting his PhD in Manchester, he studied rabbinics in Nottingham and Jerusalem. Currently at the University of Manchester, his PhD focuses on analytic thinking in rabbinic and Justinianic legal sources with a case study on the law of Delicts. He will present the topic, Setting a New Abstract Framework for Delicts in Justinian's Institute, 533 CE. Please.
I didn't expect so many people, so I have only 20 handouts, so please share one. Some of the sources will be on the slides too. And just like the person before, I will read the presentation. Definitions of key terms and their systematic presentation are golden standards of the modern textbook. An introductory chapter delineates and defines the subjects, arranges into smaller topics, and discusses them in a logical order, proceeding from the elementary to the more advanced and complex. A standard textbook of grammar proceeds from phonology via morphology to syntax. A standard textbook of chemistry discusses the atomic structure first before approaching bonding and reactions. In each part, the key terms are defined and they are expected to be used in a coherent fashion throughout the book. By the time the student reaches the final pages, the definitions and the systematic presentation have become his second nature. His mind has become accustomed to the idea of the arranged whole, constituted by distinct and clear parts. Trained in such way, the student almost hesitates now to accept the idea of the whole is a human institution which does not reflect the state of matters. Emperor Justinian, reigning between 527 and 565, had a similar idea of the arranged whole in mind when 3 years after his rise to power, he commissioned as, quote, a completely full revision of the law, distributed into 50 books and distinct titles. Similarly to his codex, the project, which was given the name Digest or Encyclopedia, is pronounced to have, quote, no place for any antinomy, but be in total concord, total consistency, with no one raising any opposition, end quote. The Codex and the Digest were not to set down any laws fallen into disuse. The two works were commanded to have exclusive authority, which should not be confused by any future commentaries. At the same time, Justinian also commissioned an elementary work by the title Institutes, quote, so that the immature mind of the student, nourished on simple things, may be more easily brought to knowledge of the higher learning. The present paper emphasizes the didactic considerations of the Justinianic corpus in general and the elementary work of the institutes in particular, and it argues that apparent inconsistencies can be explained against the background of the proposed reform plan of the legal curriculum. The paper briefly summarizes the different classifications of obligations as found in the works of the 2nd century Gaius and the Institutes of Justinian, and asks if there is no place for any antinomy. One may wonder how contradictory classifications can appear in different parts of the Justinianic corpus, one in the Digest, preserved under the name of Gaius, and another in the Institutes. In order to present a solution for this question, my paper outlines Justinian's reform plan of the legal curriculum and suggests that the institutionalized study of law generated the need to create the ideology of a coherent legal system which can be effectively communicated to the novice student of law. As students later immersed themselves into the study of specialized subfields and acquired a better understanding of the legal vocabulary and the particular legal institutions, the initial ideology gradually became irrelevant. Advanced students could realize that the ideology needed to be treated with a pinch of salt. That is, it simply provided the didactic starting point for the novice and the idealized endpoint for the master of law. The standard reconstruction of the development of Justinian's classification of obligations posits a straight line from the early via the mature Gaius to Justinian. The Institute of Gaius, as the most significant and the only independently available predecessor of Justinian's institutes, presents a twofold structure, the source number 1 on your handout. Let us now proceed to obligations. These are divided into two main species. For every obligations arises either from contract or from delict. According to the standard reconstruction, Gaius realized in due course that he was unable to account for a number of legal phenomena which, on the one hand, fell under the general label of obligatio, but, on the other hand, did not fit either of the two major classes of contracts and delicts. For this reason, follows the argument, Gaius acknowledged a third miscellaneous class in his Res Quotidianae and created a threefold structure. The source is preserved in three fragments of Book 44, Title 7, about the obligations and actions in the digest. That's source number 2 on your handout. Obligations arise whether from a contract, from a wrong, or from various other causes by operation of the law. The traditional understanding underlines that Gaius actually anticipated the class of quasi-contracts and quasi-delicts when discussing exceptions which cannot be classed as either arising from contract or from delict. According to this reasoning, the institutes of Justinian simply took the necessary step anticipated by Gaius and created the separate classes of quasi-contracts and quasi-delicts by dividing the third miscellaneous class of Gaius into two. That's number 3 on your handout from the Institutes of Justinian. We turn to obligations, which divide into 4. Obligations arise from a contract, as though from a contract, from a wrong, or as though from a wrong. Neat and logical as this reconstructed linear development may seem, Justinian's fourfold classification is rather a step back to the twofold classification and its rigid boundaries. The miscellaneous third class of Gaius Res Quotidianae allows to list special legal phenomena with their peculiar regulations and thereby provides the classification with the necessary flexibility. By dismissing the miscellaneous class and creating two additional ones hanging respectively on the class of contracts and the class of delicts, Justinian poses an unnecessary challenge to himself and his modern commentators. Firstly, that each of the 4 classes has a common characteristic, and secondly, that all legal phenomena grouped under the general label of obligatio should be put in one of the 4 classes. Within this rigid framework, all possible exceptions need to be explained away or left unexplained. The neat and symmetric fourfold structure, which reappears in other parts of Justinian's institutes, is rather thanks to didactic considerations of, quote, the first cradle of the laws, dedicated to a readership of young people desirous of legal matters. For the elementary purpose of the institutes, Justinian preferred neatness over flexibility. In the context of Justinian's reform plan of the legal curriculum, we can alleviate the tension between the fourfold classification of the institutes and the perplexing threefold Gaian classification preserved in the digest. In 530 CE, the Constitutio Deo Auctore commissioned the creation of the digest and the institutes in an open letter addressed to the Quaestor Tribonian. 3 years later, a series of imperial pronouncements greeted the completion of the enormous project. The Constitutio Tanta and Dedocen announced the publication of the 50-book digest to the Latin and Greek-speaking world. The Constitutio Imperatoria served as a short preamble for the publication of the institutes, while the Constitutio Omnem outlined the curriculum of the reformed legal education based on the newly published works. You can now turn the handout. The picture arising from reading the 4 imperial pronouncements together is that the didactic and legislative purposes are harmonized in Justinian's legal enterprise. The Institutes is an elementary textbook as well as binding law. The digest is a thematically arranged source book for legal students as well as binding compendium for legal practitioners. The Codex is a collection of binding imperial constitutions to be studied by the advanced final year students of law. The three pillars of the Justinian corpus are meant to be the definitive work in educational as well as in legal terms. Together with the imperial constitutions, published in the revised second edition of the Codex, the institutes and the digest are ordered to replace all legal works once and for all. The project wanted to give ancient laws a new elegance and reduce them, as quote, to a single harmonious whole, so that nothing should be found in it which was contradictory or identical or repetitious. A remarkable note in the Constitutio Tanta, however, acknowledges that the original goal has been overambitious. As quote, for the heavenly providence, this goal of the original project was certainly appropriate, but for human weakness is no way possible, end quote. Due to three unavoidable obstacles, the limited extent of human intelligence, the intrinsic difficulty of the matter, and the character of human law, which is always to hasten onward, the end product could not meet the original target and necessarily became nothing but imperfect and temporary. In order to correct the faults and adapt to new conditions, the emperor reserved the exclusive authority of providing legal remedies, since, in truth, God has set the imperial function over human affairs. Well informed by the members of Tribonian's committee, Justinian reports about the distressing state of legal education in the Constitutio Omnem before setting the new curriculum. The reform plan did not revolutionize the thematic structure of the curriculum in use, but provided with a new and didactically superior framework. You can follow this reconstructed legal curriculum on the handout and also on the slide. In the first year, the Institutes of Gaius was replaced by a new institute, which was supplemented with the discussion of jurisprudence, Roman legal history, Roman legal sources and offices, procedural matters, as well as some complex case studies, which gave students a taste about the subtleties to be discussed in subsequent year. Similar to the previous curriculum, the legal branches of legal proceedings, and things were introduced in the second year, but Justinian advised that students should study only one of the two, either legal proceedings or things. In the reformed Justinianic framework, legal knowledge could be approached from the perspective of the legal process, as well as from the perspective of the substantive legal institutions. They were considered to be alternative routes to the same goal. Second-year students were also introduced into the four topics of the vice property, tutelages, wills, and legacies, which had been removed from the first year and had been expanded into four thematic works as subordinate sections in parts 4 and parts 5 of the digest. The 7 parts of the digest is table 1 on the handout. The first engagement with these four topics in the second year is restricted to the first book of the thematic sections. Just like in the old curriculum, the third year interpolated materials which were based on the works of the Juris Papinian. The first section in part 4 of the digest, and especially its constituent book 20 on mortgages, presents material mostly from Papinian and thereby introduces his style and method before students start studying Papinian's works themselves. As in the old system, third-year students were obliged to read Papinian's replies together with his questions, definitions, and his works on adulteries. The full engagement with the four topics of the vice property, tutelages, wills, and legacies is delayed until the fourth year. With the first books of each thematic works studied in the second, fourth-year students were expected to complete the reading of these works according to the remaining 10 books. The fifth and final year of the curriculum shows a practical consideration by setting the 12 books of the Codex as the obligatory study material. The last two parts of the digest, part 6 of books 37 to 44 and part 7 of books 45 to 50, are made only optional, which, quote, must be put on one side so that the students can read them later on and display the knowledge of them in court, end quote. What is crucially important for our own subject, and now I conclude, is the fact that book 44 of the digest, title 7, De Obligationibus et Actionibus, which supplements the classification of obligations presented in the institutes, belongs to the optional Part 6 of the digest. Legal practitioners were expected to be familiar with the material, but it did not even form part of the obligatory legal curriculum. We have the fourfold classification of obligations in the first year compulsory text of the institutes on one side, and the alternative threefold classification in the fifth year optional text of the digest on the other. One for the complete beginner and the other for the very advanced student of law. The attempt to harmonize them as if they formed a coherent whole would be unwarranted. We may go as far as saying that from the vantage point of the advanced student, the classification and the corresponding ideology of law as coherent system is almost irrelevant. Once the student is able to identify what response a particular legal event triggers, it becomes secondary whether they form a neat, symmetrical, and intuitively appealing system. Thank you.